I thought about the objections to Ms. Moser's proposed testimony or anticipated testimony, and so let me go through those quickly. First of all, I appreciate Ms. Brady bringing this up ahead of time. It's helpful, and it avoids having interruptions during the testimony. The first 3 points that she made, I look at as part of one objection because I look at them together, and that is that Ms. Moser apparently intends to testify that she dropped off her daughter at a babysitter's residence so that she could have an ultrasound or attend an ultrasound appointment, that she then was excited about hearing news that she was going to have a baby and wanted to celebrate, and that for that reason she took her daughter and I think Kaylin Bailey and perhaps someone else to the movie, and that she thought the Batman movie was going to be a cartoon movie, but then thought, oh my God, I hope Veronica won't be scared, end quote. And the objection is under Rules 401 and 403. So let me address 401 first. The question under Rule 401 is whether this is relevant, and I think it is. It is relevant because I think Ms. Moser is entitled to explain why she brought I think a 6-year-old child to a midnight movie on the day in question. We heard at least a couple of prospective jurors during jury selection question why a mother would bring her young daughter to a midnight movie, especially a midnight premiere of Batman. And so I think she's entitled to explain that. I don't know whether any of those prospective jurors ended up making it on the jury, but I think it's a natural question that people may have, and I think it's a question that some of these jurors may have. And so I think that she's entitled to explain why she brought her young daughter to this movie. So it is relevant. The question then under 403 is whether the probative value of the evidence is substantially outweighed by the danger of unfair prejudice. And I believe that that's the concern for the defense when the defense cites Rule 403, and if not, the defense can correct me. But if the jury was not going to hear that Ms. Moser was pregnant and that she lost her pregnancy as part of the shooting and the injuries that she sustained during the shooting, I likely would keep this out, because I would say, okay, the probative value is there is some probative value, but the potential for undue prejudice substantially outweighs that probative value. But in this case, I've already ruled that the jury can hear that Ms. Moser lost her pregnancy as a result of the injuries that she sustained in the shooting. So having the jury hear that she had an appointment for an ultrasound and that she found out that day that she was going to have a baby and wanted to celebrate, I don't think that is so prejudicial that it substantially outweighs substantially outweighs the probative value of the evidence. It's not particularly prejudicial, and I find that it is not unduly or unfairly prejudicial. So I'm going to allow that anticipated testimony. The next point had to do with Veronica Moser wanting to sit on her mom's lap, and Ashley Moser telling her no because she was pregnant and it was uncomfortable, and Ashley Moser then wanting to say or testify that the last thing she said to her daughter is, "You're a big girl and you can sit in your own seat." And there's an objection as under Rule 401, Rule 403, and under Rule 802. I'm going to sustain the objection with respect to this issue. What's relevant is not why Veronica was sitting in her own seat or what seat she was seated in. What's relevant is the fact that she was seated in that seat by herself. That's what's relevant. And I'm not concerned that if I don't allow an explanation that the jury is somehow going to be wondering why, or going to be distracted by that, or going to be speculating about that. Veronica was 6 years old at the time, and I don't think there's anything unusual with a 6-year-old sitting in her own seat at a movie theater. So Under Rule 401, I find that this has no probative value, and so it is inadmissible. And because of that, it is also inadmissible under Rule 403. Actually, I don't have to get to Rule 403, so I'm keeping it out under Rule 401. But to the extent, yeah, go ahead.
I apologize for interrupting, but as we go through these, if I ask for some clarification, do you want me to wait for the end and come back, or do it as we go?
Why don't you ask me as we go through it?
Just so that I'm clear on this one, and I understand the court's ruling, is
Yes.
it as to the statement that Ms. Moser Sullivan made to her, or the act of her daughter initially sitting on her lap, but then because it was painful being put in that seat, or both of those things?
She can testify that she initially sat on her lap and that then later moved to her own seat, and that she was uncomfortable, she felt uncomfortable. You'll just have to avoid any hearsay. So she can't testify about what she said or why she said it or anything like that. Nor can she testify about what the last thing is that she said to her daughter. And to the extent that there's any probative value to this, the probative value is substantially outweighed by the danger of unfair prejudice.